Sue someone in small claims court. Chapter 1. Filing a small claims case. The golden rules of small claims court. The two golden rules at either end of a court case are to study the system first, then play goody two-shoes to the judge. Sit in on a few court cases, especially the ones that your judge is presiding over. You might glean some legal knowledge by watching court shows on TV, but study the people involved so you will know how to deal with them when the time comes. Judges are emotional human beings who think themselves very intelligent, and many are, having spent years in the legal system dealing with all kinds of characters, so they're probably slightly cynical by now. Be a stand-up, respectable, straight-up person. The courtroom is the judge's church. Dress correctly. Show respect. Use your common sense. Though bound by law, many judges make decisions based on gut instinct emotion. In order to believe you, you have to come across as a good, all-around person. Small Claims Court Info 1. Small Claims Court, generally the lowest order of court in the land, also called Magistrates' Court, People's Court, or Justice of the Peace Court, is where you go to stake a monetary claim against someone else for what is called breach of contract for compensatory damages, an amount of money that will compensate you for damages sustained, generally a maximum monetary amount of between $1,500 to $5,000, although small claims courts can go as high as $15,000 in some jurisdictions. You can also claim court costs and interest. You cannot collect for aggravation, only for the actual, physical damages caused. You can only sue for money, not what is called equitable relief, where you get an injunction stopping someone from playing their stereo late at night or something like that. While the maximum amounts that can be claimed or awarded differ from state to state, small claims court procedures are generally simple, inexpensive, quick, and informal. Court fees are minimal, and you often get your filing fee back if you win your case. Generally, you will not need a lawyer. In fact, in some states, lawyers are not permitted. If you live in a state that allows lawyers and the party you are suing brings one, do not be intimidated. The court is informal, and most judges make allowances for litigants who appear without lawyers. Even though the court is informal, the ruling is legally binding, just like the ruling of any other court. If the party bringing the suit wins the case, the party who lost often will follow the court's decision without additional legal action. Sometimes, however, losing parties will not obey the decision. In these cases, the winning party has to go back to court and ask for the order to be enforced. Depending on local laws, the court might, for example, order property to be taken by law enforcement officials and sold. There might be a monetary charge of $20 or so to get law enforcement authorities to act on your behalf. The winning party will get the money from the sale, up to the amount owed. Alternatively, if the person who owes the money receives a salary, the court might order the employer to garnish or deduct money from each paycheck and give it to the winner of the lawsuit. Check your local telephone book under the municipal, county or state government headings for small claims court offices. When you contact the court, ask the court clerk how to use the small claims court. Many state and local consumer agencies have consumer educational material to prepare you for small claims court. To better understand the process, sit in on a small claims court session before taking your case to court. Many small claims courts have created dispute resolution programs to help citizens resolve their disputes. These dispute resolution processes, e.g., mediation, arbitration, and conciliation, often simplify the process. In mediation, both people involved in the small claims dispute meet, sometimes in the evenings or on weekends, and with the assistance of a neutral, third-party mediator, discuss the situation and create their own agreement. When you contact your small claims court, ask about their mediation, arbitration, or conciliation process. For additional information about dispute resolution, contact American Bar Association. Standing Committee on Dispute Resolution. 1800 MST, NW. Washington, D.C. 20036. 202-331-2258. americanbar.org/public. The kinds of cases heard in small claims court are: dry cleaner lost or damaged clothes, repairman charged too much or didn't repair an item properly, tenant charges that a landlord refused to return the deposit, travel agent failed to arrange a tour as promised, store sold shoddy merchandise, dog bite, car accident, ex-lovers, ex-roommates, virtually anything else. Just watch them court TV shows sometimes. You can bring a lawyer, but people generally represent themselves, known as pre-SC representation. Some small claims courts operate at night to avoid the inconvenience of day sessions for people who work during the day. If you're representing yourself, follow these steps. First, try to resolve the conflict with the person or business on your own. Send them a certified letter stating your intention and offering them a chance to resolve it without going to court. If it's a business, consider an approach like threatening to expose the bum to a local consumer reporter unless you get your money back. It just might work. If you can't resolve it between the two of you, get all the paperwork you can on your complaint, such as cancelled checks, contracts, etc. Videotape evidence such as a dented car or a shoddy home repair job and take an objective look at it all. Determine if you can win such a case. Possibly call a lawyer or legal aid service and run your beef by them to get their opinion as to whether you should proceed. Maybe go to the library and take a look at a logbook to see where exactly you stand in legal terms. Get a filing form from the court. Fill it out, stating your name, your complaint, and who you are complaining about, their name, address and phone number. You can state 2 defendants for 1 violation, such as a manufacturer and retailer, and let the court decide who's at fault. Make sure your claim doesn't go over the maximum claim limit, because then you will have to go to a higher court. File your complaint with the court clerk and pay a filing fee of about $5 to $40. The complaint is processed and a summons is made, which is given to the party you are suing, generally by mail or registered mail, telling him or her to appear in court on a particular date and time to answer to the charges. The person you are suing has the right to file a countersuit against you, or they might contact you and try to settle out of court. Accept only cash in a settlement and don't cancel the suit until you're paid. If necessary, get the clerk to subpoena reluctant witnesses. During the trial, you will each have a chance to present your side of the case, bring witnesses, and show evidence such as photos or videotape or anything else you deem useful. The person you are suing may exercise his or her option to bump the proceedings up 1 notch to a trial court where the damages are higher. The procedures are more complicated here, and you might considering hiring a lawyer. Even if you decide to represent yourself, which is your right, you might consider getting some professional advice from a paralegal or lawyer on the side. Sometimes lawsuits become more of a matter of ego and principle than money. An angry neighbor might spend a significant amount of money and time on a case allegedly just to try to get rid of the neighbor's dogs, but it sometimes escalates to become more personal, with each side trying to win at all costs regardless of the money expended or judgment. The point is to think hard before proceeding with a lawsuit, especially if it involves hiring a lawyer. Your best bet is to find a lawyer who will work on a contingency basis, getting nothing up front but up to 30% of the judgment should there be one in your favor. Lawsuits are damaging in both ways, forcing the defendant to waste time, nerves, and money on his lawyers, so it's not a very pretty thing no matter how you look at it. There will be a loser, and the judge may make you both losers by awarding nothing, in essence, making it all a big waste of time with the animosity still there and nothing solved. Remember that you are responsible for court costs such as filing fees. In some jurisdictions, if you file a lawsuit and lose, you have to pay for the defendant's legal fees. Sometimes the lawsuit is not worth it simply on the practical grounds of time expended, and especially if you have to hire a lawyer. Suing a landlord for a $100 security deposit may be a waste of time when you consider your filing fee, preparation of the case, taking time off from work to go to court, and then the hassle of collecting the judgment if you know up front he's a louse and will probably refuse to pay even if he loses. In that case, you have to take further action to get your money back. If the party bringing the suit wins the case, the party who lost often will follow the court's decision without additional legal action. If the losing party will not obey the decision, you have to go back to court to file a petition for notice to show cause and ask for the order to be enforced. You should also file a notice of execution with the sheriff's or court clerk's office. Depending on local laws, the court might order property to be taken by law enforcement officials and sold. The winning party will get the money from the sale, up to the amount owed. Alternatively, if the person who owes the money receives a salary, the court might order the employer to garnish or deduct money from each paycheck and give it to the winner of the lawsuit. It's estimated that up to 50% of judgments in small claims court are never collected. First, contact the defendant or his attorney if he has one and ask for payment. If he refuses, contact the office of the clerk for the court, who will probably direct you to the sheriff or the marshal, who has legal grounds to seize the defendant's property and slash or garnish his wages until the judgment is paid. In some cases, the defendant can be ordered to return to court to explain his financial position, and slash or legal measures can be taken to obtain a restraining order which freezes or ties up the money in a defendant's bank account until the judgment is collected. If the defendant owns a house, you can get a judgment against the house which pays you the judgment with interest when the house is sold. If the judgment is against a business, you can go to their licensing board to put pressure on them. Federal and state governments are difficult to sue, though they can be with the aid of a lawyer. Local governments can be sued just like any company. If you're injured by someone in the employ of someone else, sue them both. Books about small claims court are at number 347.710-713 or KE1090, KE8276 and KF8769 at the library. Small Claims Court Info 2. Filing a lawsuit in a trial court is one notch up from a small claims court. It is basically the same process, but the stakes are a little higher. The damaged party makes a complaint with the court and files the papers. You simply fill out some documents and give them to the court clerk along with a filing fee. A judge is randomly assigned to the case and decides on pre-trial and trial motions, etc. Usually a process server or a local sheriff's deputy will serve the defendant the summons, making it appear all the more serious, which it is. After being served with the summons, the defendant has 30 days to respond, usually in writing, by denying most of the plaintiff's claims, and possibly filing a counterclaim against the plaintiff. If the defendant does not respond at all, he or she, in all likelihood, will lose the case by default. The defendant can either admit fault and dispose of the case right there, or more likely, plead not guilty and perhaps file a countersuit against you. Or the defendant could deflect blame and bring other defendants into the case with him/herself. The defendant could also work out an agreement with you or your lawyer and settle the case out of court. If the defendant's lawyer thinks that you have a weak case, he or she may file a motion for summary judgment with the court. If the judge agrees that you or your lawyer have failed to state a valid claim, the court may simply dismiss the case without a trial, or the judge may advise your lawyer to reword the case with another more sound law/statute. If it appears that the lawsuit will proceed to trial, the next stage of the process is called the discovery phase, where each side jostles around, investigates and generally interacts with each other through sworn oral statements, depositions, and/or sworn written statements, interrogatories. Each side has the right to question the other and may hold pre-trial conferences where the lawyers hash it out and try to reach an agreement without going to trial. During this time, the attorneys file motions called a request for admission to get rulings on the admissibility of certain evidence, and they might also ask the court to assist in obtaining documents and records that the other side is legally obligated to turn over. This process may take up months and even years of time in some cases. After all this is done, the judge will call a pre-trial conference where he will actively encourage both sides to reach some kind of settlement without ever going to trial. Since many civil cases take years to resolve, it might be a good idea to take the settlement if one is offered to you. Some lawyers may want to take the settlement because it's easy, no hassle money for them. You have to decide what's best for you. Because legal fees, time wasted and nerves play so much into it, many large corporations facing lawsuits sometimes simply make an offer which will save them money over the legal fees they expect to pay out anyway. If the plaintiff accepts it, both parties agree to the settlement and the situation is resolved without ever going to trial. Many cases are resolved without ever going to trial. If there's a trial, the defendant can choose whether he wants a judge or jury to oversee the case and pass final judgment. The jury is picked during the jury selection phase. You each present your case in the conventional fashion: opening statements, presentation of evidence, cross-examination, closing statements, and if you win, you collect damages. In some cases, the lawyer for the defense can ask the judge to dismiss the case outright if you, as the prosecution, have not met your burden of proof. Juries in civil cases generally consist of 6 to 8 people and require a 75% consensus to find the defendant liable for damages. The way the trial goes. The typical events of a trial are: the bailiff calls the case. The defense and the prosecution both reply with, "Ready, Your Honor." The prosecution will give their opening statement. The defense will give their opening statement. The prosecution will present their case. They will have the police officer's testimony. There will be cross-examination by the defense. There will be a redirect by the prosecution. Any physical evidence that happens to be available will be brought to light at this time. Any diagrams, citations, that sort of thing, then the prosecution will rest. If you have the grounds, you will make your motion to dismiss, on non-applicable grounds at this point in time. The defense case will include your witness, either you or your passengers. Cross-examination by the prosecution. Redirect by the defense and you as the defense, will rest. Next will follow the rebuttal of the witness by the prosecution. The closing arguments by the prosecution, by the defense, and then the prosecution gets another chance to make a follow-up and respond to the defense closing. The verdict will be issued shortly thereafter and then you will get sentenced if guilty. If you lose as the plaintiff, it was a big waste of time, a lot of embarrassment, and you still have to pay court fees. If you win, it could be the beginning of a long hassle. The losing party may not want to pay, therefore you have to take further legal action. You have to pay your lawyer and expert witnesses as well as court costs. You may even have to hire a specialized negligence lawyer, whose expertise is to get losers to pay up. If you lose, you might try for an appeal if you can show good reason why the first trial was faulty in some way, but take note that appeals can be costly and time-consuming. Malicious prosecution is a process whereby someone brings suit against another without proper cause with the intention of injuring the defendant. Consider options like mediation and arbitration. Don't bother filing a civil suit if the other guy can't pay the judgment if he loses. Preponderance of the evidence is a term used in civil cases where you win by tipping the scales, essentially showing that your evidence is 51% or more accurate. If you feel you have been unjustly dealt with in any court or any matter of life, try writing a letter to both your federal congressman and senator explaining your position and asking for help. Appeal a small claims verdict. With every trial there is a loser who has a limited time period, usually about 30 days, to decide if he wants to appeal the case. In some jurisdictions, but not all, if the plaintiff loses the case, he does not have the right to appeal. Only the defendant does. In some jurisdictions, the plaintiff can appeal his loss. Grounds for appeal are: evidence was introduced that should have been excluded. Evidence was obtained that violated the defendant's rights. Evidence was not available before the trial to enable the defense to set up an adequate defense. New evidence is discovered that would have had a significant impact on the trial. With convictions in serious felony cases, an appeal is automatic, such as in death penalty cases. Small claims court websites: law.freeadvice.com/resources/smallclaimscourts.htm, small claims court links to each state. uslegalforms.com/small-claims, download small claims forms for every state. consumeraffairs.com/consumerism/small_claim_01.htm, consumers guide to small claims court.
court.lawwelp.org. courtinfo.ca.gov/self-help/small claims. courts.ca.gov/courts/divs/small/index.shtml